ಈಗ ಏನಾಗಿದೆ, ಸೆಕೆಂಡ್ ವೈಫ್ ಇಲ್ಲ, 2 ಚಿಲ್ಡ್ರನ್ ಇದಾರೆ, ಫಸ್ಟ್ ವೈಫ್ ಇದಾರೆ, ಅವ್ನ್ ಮಗ ಇದಾನೆ, 4 ಜನ ಈಕ್ವಲ್ ಶೇರ್ ಬರುತ್ತೆ. ಬಟ್ ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ದು
plaintiff only. That is not in the finding alla ide. They are wife and husband. Even though he has taken the second marriage and 3 and 4 are proved to be the legitimate children anta finding ಕೊಟ್ಟಿದ್ದಾರೆ. Page number 52 ನಲ್ಲಿ. But when there is a first marriage is subsisting and he has admitted, and even finding also given by the appellate court that they are the
wife and children, wife and son.
Moreover, my lord, they have not sought for any declaration that they are the wife and children. In spite of that, my lord, the appellate court has
service records ಅಲ್ಲಿ ಯಾರ ಹೆಸರು ಎಂಟ್ರಿ ಮಾಡಿದ್ದಾರೆ?
Nominee ಇದರಲ್ಲಿ the third defendant name has been mentioned.
Third defendant is the second wife.
Oh, second wife. Her name has been on that ground. On that ground, endorsement has been issued by the respondent third Pescom.
Because nominee is shown as third defendant and hence not entitled for compassionate appointment. ಈಗ ಇನ್ನು compassionate appointment ಯಾರಿಗೂ ಆಗಿಲ್ವಾ?
ಇಲ್ಲ, ಕೊಡ್ಲಿ.
Yes, counsel, what do you say?
My lords, I would like to have my lords kind attention to RA, my lords, wherein the court clearly held.
Madam, now I wanted to make it clear now. Regarding, even if first wife is alive, if any person contact the second marriage, if any children born in second marriage, they can be considered only in respect of the property of the father as a heir. That is the law. Now law is settled. Maybe the second wife is not entitled for any share, but other children are also entitled for a share in the property. ಏನು ಹೇಳ್ತೀರಿ ನೀವು ಇಬ್ರು?
Please, my lord, to that effect, I would like to substantiate my argument by providing some of the judgment of honorable Supreme Court and High Court.
ಆ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಅಲ್ಲೂ ಅದೇ ಹೇಳಿರೋದು.
Please, my lords.
Not in respect of ancestral properties, they are not entitled.
Please.
But if it is a property belongs to a father, they are equally entitled anta.
To that effect, I would like to take my lord's kind attention to Supreme Court judgment, my head note A, B and C. With the permission of this honorable court, I would like to read out those lines. I quote, Constitution of India, Article 16(2), equality of opportunity in a matter of public employment. Article 4, equality of opportunity in a matter of public employment. Article 14, equality before law. Hindu Marriage Act 1955. Section 16, legitimacy of a children of wide and wideable marriages. The real issue in wideable marriages. The real issue in the present case, however, is whether the condition which has been imposed by the circular of the railway board, under which compassionate appointment cannot be granted to the children born from second marriage of a deceased employee, accords with the basic notion of fairness and equal treatment, so as to be
consistent with Article 14 of the Constitution.
Article 16 of the Hindu Marriage Act 1950, Section 16 of the Hindu Marriage Act 1955 regards a child born from a marriage entered into while earlier marriage is subsisting to be legitimate. It would not be open to the state, consistent with Article 14, to exclude such a child from seeking the benefit of compassionate appointment. B, to deny compassionate appointment through the law treats a child of a wide marriage as a legitimate is deeply offensive to their dignity and is offensive to the constitutional guarantee against discrimination under Article 18. The court is of opinion that apart from being textually sound, understanding decent in terms of prohibiting discrimination against a person on the basis of legitimacy or on the basis of his mother's status as a first or second wife fits within the principles underlying Article 16 subclause 2. Not only is one's decent in this sense entirely beyond one's control, but it is also an established fact that the child of second wives, whether counted as legitimate or illegitimate, have often suffered several social disadvantages. My lords, to this effect, my lord, pleading as if I got into marriage on 1990, my lords. According to their version, 1980 is the marriage took place between late Shivanna and Barmakka, my lords.
89.
89, my lords. Within 3 months, there is second marriage, and even in cross-examination, my lords, with the permission of my lords, kind permission, I would like to read out the cross-examination, my lords.
What is the material emerged during the course of evidence with regard to the first wife and second wife is concerned?
Please, my lords. My lords, here, as per,
Whether both the courts have given consent that the first marriage 22/3/1990 was held or not?
my lords, as far as that point is concerned, my lords, court uttered no word at all, my lords. As far as defendant number 4 and 5 is concerned, my lords, at page number 4, paragraph number 46 of RA, my lords, wherein they have clearly held in MC, my lords, very Shivappa itself, my lords, stated that he married to second defendant number 3, my lords. Because of that reason, my lords, they blessed with 2 children, that is defendant number 4 and 5, my lords. That is present Sahana and Ashwath, my lords. This is what the observation made by court below, my lords, by moving to the document as presented by the plaintiff only, my lords. My lords, here, by looking into this very judgment, my lords, it clearly states about.
Earlier there was a dispute with regard to the
Please,
claim.
my lords, there is a dispute between Shivanna
During
and
the lifetime
Barmakka, my
of
lords.
father Shivanna.
Shivanna and Barmakka, my lords.
Ah.
My lords, what they are claiming is this, my lords.
What was the result of those dispute?
My lords, in MC, my lords, it was decreed in favor of
Barmakka.
please, my
Barmakka.
Barmakka, my lords. My lords, here we are only taking the very crux of that MC, my lords, wherein the court clearly held that, my lords, here in the MC itself, my lord, Shivanna agrees and admits that, my lords, he has contracted with second defendant number 3, my lords, blessed with 2 children, my lords. That has been very
No
clearly
dispute
observed
with
by.
regard to the marriage is concerned, but even assuming that you are also the wife and children of the Shivanna.
Please, my lords.
Now,
My
what
lords,
made the trial court and appellate court to trial court decreed?
please,
Appellate court reversed the same.
please, my lords.
Once they comes to the conclusion that the Barmakka and the second appellant is this wife and son, what made the appellate court to dismiss the suit?
My lords, here, the declaration is the only declaration that they are sorting before this court, trial court is this, my lord. They are the only legal heirs. That is what the problem, my lords. Only is the only problem, my lords, because even Shivappa himself
Appellate
admits.
court would have declared that both of them are also the legal heirs and
There in
legitimate
the
children. in
trial
the
court,
recent judgment of Apex court.
Please, my lord.
Now we cannot call any person as an illegitimate child.
please,
That is
please,
the now law is evolved.
please, my lords. Without looking into that, my lords, trial court erred in partly decreeing the suit, my lords. Against that, we have preferred the suit, my lords. Against that, we have
That
preferred
would have been
RA.
modified, that's all. In the appellate court. Instead of dismissing the very suit. That would have been modified.
As far as their prayer is concerned, my lords, it requires to dismiss very OS itself, my lords.
Why,
Because
madam?
they are claiming they are the only legal heirs. Because as
ಆಯ್ತು ಮೇಡಮ್ ಅದಕ್ಕೆ ನಾನು ಹೇಳ್ತಾ ಇರೋದು ಇನ್ಸ್ಟೆಡ್ ಆಫ್ ಡಿಸ್ಮಿಸಿಂಗ್ ದಿ ಸೂಟ್ ದಿ ಸೇಮ್ ವುಡ್ ಹ್ಯಾವ್ ಬಿನ್ ಮಾಡಿಫೈಡ್ ದಟ್ ದಿ ಸೆಕೆಂಡ್ ವೈಫ್ ಚಿಲ್ಡ್ರನ್ ಆರ್ ಆಲ್ಸೋ ದಿ ಲೆಜಿಟಿಮೇಟ್ ಚಿಲ್ಡ್ರನ್.
please, they are legitimate owing
Ah.
to the very section 16, my lords. Second point is about section 7 of Hindu Marriage Act, my
Ah.
lords. Here, Barmakka is claiming she is the first wife of Shivanna, my lords.
That's the reason
Without
only,
providing
that is the
single
reason
document.
only I suggested you both decide with regard to the compassionate ground is concerned. Who is entitled for compassionate
That's when
appointment?
she is coming before
And
the court.
both of you cannot claim as a matter of right compassionate ground. That is discretion of
Please, please.
the employer.
But we
Please.
suggested, my lord, for compassionate ground for employment, for certain majority, he made the application for compassionate ground application.
Before the authority.
Please,
Ah.
they are not ready to give that.
My lords,
Stop to the-
one hand, they are claiming they
He-
are the only legal heirs. Now
ಆಯ್ತು
they
ಮೇಡಮ್
are
ಅದನ್ನ
submitting before this
ನಾನೇ
court.
ಮಾಡ್ತೀನಿ ಬಿಡ್ರಿ ಅದಕ್ಕೆ ಯಾಕೆ ಸುಮ್ನೆ
My
ಮತ್ತೆ
lords, only one
ಓನ್ಲಿ ಲೀಗಲ್
submission.
ಏರ್ಸ್ ಬಿಟ್ಬಿಡೋಣ ಈಗ
My lords,
ಎಲ್ಲಾರು
only-
ಲೀಗಲ್ ಏರ್ಸ್
ಅಲ್ಲ,
ಅಂತ
trial court has given a-
ಸೆಕೆಂಡ್ ವೈಫ್ won't get any status.
Please, second wife is
Please,
not
she
there,
is
no.
not alive.
My lords.
Ilva,
She
not
passed
alive.
away. She passed away, my
And then now only consideration of
Of,
first wife ಇದಾರ
children.
First of ಇದ್ದಾರೆ.
ಆಯ್ತು ಹಾ
My lords,
First
only
ಇದ್ದಾರೆ,
one
ಅವ್ರಿಗೆ ಏನು
submission.
ಇನ್ಕಮ್ ಇಲ್ಲ ಏನಿಲ್ಲ, ಅವರು ದೇ ಆರ್ ಸಫಿಶಿಯಂಟ್ ಸೋರ್ಸ್ ಆಫ್ ಇನ್ಕಮ್.
ಆಯ್ತ್ರಿ ಈಗ ಈಕ್ವಲಿ ಎಂಟೈಟಲ್
My lords,
if it is a property of the ಅವನ ಹೆಸರೇನು
ಶಿವಣ್ಣ.
ಶಿವಣ್ಣ.
ಓನ್ಲಿ ಸರ್ವಿಸ್ ಬೆನಿಫಿಟ್ ಮಾತ್ರ ಇದೆ.
ಈಗ ಏನಾಗಿದೆ ಸೆಕೆಂಡ್ ವೈಫ್ ಇಲ್ಲ,
ಇಲ್ಲ.
2 ಚಿಲ್ಡ್ರನ್ ಇದಾರೆ,
ಹೌದು.
ಫಸ್ಟ್ ವೈಫ್ ಇದಾರೆ, ಅವ್ನ್ ಮಗ ಇದಾನೆ,
Please.
4 ಜನ ಈಕ್ವಲ್ ಶೇರ್ ಬರುತ್ತೆ. But ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ದು you decide with regard to the compassionate ground is concerned. ನಿಮ್ಮಿಬ್ರಲ್ಲೂ ಡಿಸೈಡ್ ಆದ್ರೆ ಮಾಡ್ಬೋದು.
My lords, ಒಂದೇ ಒಂದು
ಹೇಳಿ.
ಅದನ್ನ ಬಿಟ್ಟು
ಆರ್ಥಿಕವಾಗಿ ನಾವು ಸಬಲವಾಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ, ಆದ್ರೆ ಅವರು ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆ ಅಂತ ಹೇಳಿ ಅವರೇ ಪ್ಲೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ.
ಮೇಡಮ್ ಅದೆಲ್ಲ ಬಿಟ್ಬಿಡೋಣ ಈಗ ನಮ್ಗೆ
ಎರಡನೇ aspect, my lords, he is working in company, my lords, but as far as Ashwath is concerned, my lords, he is orphan, he is only completed his BA, nobody is there to take care of them, my lords. So because of that reason, my lords, I have quoted even
ಮಾಡ್ತೀನಿ, if you arrive for one consent for compassionate ground is concerned, that is better.
ರೆಕಾರ್ಡ್ ಅಲ್ಲೂ ನಮ್ಮ ಹೆಸರೇ ಇರೋದು, my lords, ದುರ್ಗಮ್ಮನ ಹೆಸರೇ ಇರೋದು, my lords, ರೆಕಾರ್ಡ್ ಅಲ್ಲೂ ಸಹ.
ಇರ್ಲಿ ಮೇಡಮ್ ಇರ್ಲಿ.
Even my lords, one submission, my lords.
ಫಸ್ಟ್ ವೈಫ್ ಹತ್ರ ಪ್ರಾಬ್ಲಮ್ ಆಗಿರುತ್ತೆ, ಅದಕ್ಕೆ
ಫಸ್ಟ್ ವೈಫ್ ಅಂತ ಹೇಳ್ತಾರೆ, ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ. ಬಟ್ ನಾನು, my lords, as what they have pleaded,
ಡಿಸೆಂಬರ್ ಮದುವೆ ಆಗಿದೆ, ಮಾರ್ಚ್ ಅಲ್ಲಿ ಮತ್ತೊಂದು
ಮದುವೆ ಆಗ್ತಾರೆ. ಅವ್ರ ಮನೆ ಮುಂದೆ ಮನೆ ಇರೋದು, my lords, ಅದನ್ನ ಕ್ರಾಸ್ ಅಲ್ಲಿ ಅವ್ರು ಅಡ್ಮಿಟ್ ಮಾಡ್ತಾರೆ. ಅವ್ರ ಮನೆ ಮುಂದೆನೆ ಮನೆ ಇದ್ರು, what made her to stop marriage, my lords?
Is it your dispute that she is not the first wife?
Please, my lords.
Is it your dispute that she is not the first wife?
Only for the sake of submission I am making this, my lords, for the sake of argument, my lords. Why? Because they have not produced a single document to show that she is the wife of.
Now what is the conclusion of both the courts, madam, regarding wife is concerned, his client?
Court proceedings are there. He filed a divorce petition. Divorce petition.
He filed a divorce
Shivana
petition.
has filed the divorce petition.
Shivana only filed the divorce
that is
petition.
dismissed.
But the other MC is only for maintenance,
Maintenance.
filed by you,
Please.
your client.
Please.
ಜೀವನದ ಕೊನೆಯವರೆಗೂ ನೋಡ್ಕೊಂಡಿದ್ದು ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 3, my lords. Because of that reason, we have filed so many documents simply for asking.
Natural madam, natural ಅದು.
ಅದೇ ನೋಡ್ಕೊಂಡಿದ್ದು ನಾನು, but ಈಗ benefit ಕೇಳ್ತಿರೋದು ಅವರು.
Second wife ಜೊತೆ ಮದುವೆ ಆದ್ಮೇಲೆ second wife ನೋಡ್ಕೊಳ್ಳೋದು, unless he comes back with the first wife, ಅಲ್ವಾ?
My lords, RA is concerned, my lords, it is a speaking judgment. By owing to paragraph 46 and 47, it clearly indicates. By owing to paragraph 46 and 47, it clearly indicates.
Not answering to my question.
Please, my lords.
Once they have been recognized as wife and son, what made the first appellate court to dismiss the appeal, to dismiss the suit in entirety? You answer to that question, that's all. Huh? You answer to that question, that's all.
My lord, as far as Tripathi case is concerned, my lords, this honorable court only holds that particular aspect, my lord.
Yes, madam.
Because of that reason, I have presented that also. That, my lords, even though there is a second marriage.
Now law is
children born from.
Now law is clear, madam.
Clear.
Even after my judgment also.
Please.
Now the Supreme Court made it clear.
Please.
All are entitled.
All are entitled.
Only in the property of the, if it is a separate property of a person who married.
As far as compassionate appointment is concerned, my lords, even let us presuming for a while for the sake of argument, if I am a second wife, born out of second wife, they are also quite eligible for getting compassionate appointment. That is what held in 2023
judgment. I suggested both of you comes to a consent in respect of the same. I will dictate at 2:30. ನೀವು ಏನಾದ್ರು ಸೆಟ್ಲ್ ಆಗ್ಲಿಲ್ಲ, ನಾನೇ ಹೇಳ್ತೀನಿ, ನಾನೇ ಬರೀತೀನಿ, ಅದಕ್ಕೆ ಹೇಳಿ.